Today, we're diving into a completely fascinating explainer that sits right at the intersection of artificial intelligence, constitutional law, and human rights. We are going to look at what happens when a course of 6 globally recognized AI models objectively analyzes a highly debated Chinese legal case, specifically the arrest and conviction of Dr. Chen Jingyuan. By feeding the raw case files along with the actual text of the Constitution of the People's Republic of China into these models, we get this incredibly neutral, almost detached look at how digital logic interprets human justice. It's a really unique lens, so let's get right into it. Here is our roadmap for today. First, we'll cover the facts of the Chen Jingyuan case. Second, the legal verdict. Third, the AI's freedom of speech analysis. Fourth, academic freedom and dignity. Fifth, equality and judicial process. And we'll wrap up with the ultimate AI constitutional conclusions. All right, part 1, the Chen Jingyuan case, from retweets to arrest. So, to really understand this, we need to look at the timeline. From 2019 to 2022, Dr. Chen, who is a researcher and independent scholar, was basically just browsing and reposting content online. Pretty normal stuff, right? But then in September 2022, police raided his home in Kunming and he was arrested. Things moved fast from there. By April 2023, he got his first instant sentencing in a closed-door trial, and literally just a month later, his appeal was flat-out rejected without a formal hearing. Now, you might be wondering, what exactly was he charged with? The state formally accused him of a crime known as picking quarrels and provoking trouble. We really need to define this because it's the absolute foundation of the prosecution. In the Chinese legal system, legal scholars frequently refer to this as a pocket crime. Basically, that means it's a super broad, catch-all statute. It's flexible enough to penalize all sorts of behaviors, everything from an actual physical brawl in the street to, well, posting on the internet. And the evidence used against him is where things get really interesting. The prosecution didn't build their case on original manifestos or anything like that. It was built entirely on non-original content. Dr. Chen was just forwarding official public posts from the U.S. Embassy, sharing academic discussions about complex systems like the CAP theorem, and retweeting nonviolent political cartoons and articles. He was acting as a digital curator. He was just hitting share. Moving on to part 2, the legal verdict, interpreting the facts. Let's look at how the two sides framed this. The state argued that because Dr. Chen has a PhD and is highly educated, he, quote, should have known that the posts he was sharing were false and insulting to the state. They basically used his high intelligence to presume malicious intent. Dr. Chen's defense, on the other hand, was straightforward. He argued he was an academic merely sharing ideas and exploring different viewpoints. And, crucially, he pointed out that sharing these posts caused absolutely zero measurable public disorder. But despite that defense, the court sentenced Dr. Chen to 20 months in prison. That's right, 20 months. And that stark number is exactly what brings us to the analytical core of our explainer today. Section 3, Freedom of Speech Analysis, the AI Lens. To figure out how to parse this 20-month sentence, the source documents fed the raw facts of the case to a panel of 6 digital legal scholars. We're talking about a chorus of AI models: ChatGPT, Copilot, Deepseek, Gemini, Grok, and Quen. The prompt was simple: synthesize an objective legal analysis of the verdict, and do it strictly by referencing the Constitution of the People's Republic of China. No outside politics, no external biases. Just the text of the Constitution weighed against the text of the court's verdict. So, where did the AI models start? Well, they all immediately locked onto Article 35 of the Constitution. This is the foundational guarantee of freedom of speech and the press for citizens. The AIs essentially used Article 35 as their baseline to evaluate the validity of that picking quarrels charge. And the models reached a really tight consensus very quickly. They collectively concluded that retweeting public posts, sharing nonviolent critique, and discussing academic thoughts unequivocally fall under protected expression. They also pointed out that using a vague pocket crime to punish these actions essentially creates systemic suppression of a constitutional right. ChatGPT actually phrased it perfectly in its analysis. In constitutional law, freedom should always be the baseline principle, and restriction should be the absolute strict exception. Section 4, Academic Freedom and Dignity. Intellectual curiosity on trial. The models didn't just stop at free speech. Deepseek, Grok, and Quen zeroed in on Article 47, which protects scientific research, and Article 38, which protects human dignity. They noted that Dr. Chen was engaging in cross-disciplinary learning. For a scholar, gathering and sharing diverse, even controversial theories, is fundamentally an academic activity, which means it should be protected by Article 47. Now, during the closed-door trial, something really striking happened. When Dr. Chen tried to use the CAP theorem, an academic concept about complex systems, to defend his actions, the judge reportedly shouted, "Shut up, answer yes or no." The AI models, specifically Deepseek and Quen, flagged this moment as a severe breach of his constitutional right to a defense. They noted it reduced his intellectual capacity to forced binary compliance. Basically, the models observed a total inversion of constitutional protections here. Instead of his PhD being respected as a mark of scientific capability, it was weaponized as proof of deliberate guilt. And instead of protecting his human dignity under Article 38, the system labeled him an unemployed provocateur. Quen went so far as to describe this as a direct act of institutional humiliation.
Section 5. Equality and judicial process. The right to complain.
Next, the AI models caught a massive procedural inconsistency. Grok and Quen pointed to Article 33, which guarantees equality before the law. Here's the issue. Dr. Chen was sentenced to prison for forwarding posts, but the original creators of those posts, and even state media outlets that published the exact same articles, faced zero legal consequences. The AI noted this kind of selective enforcement completely contradicts the core principle of equal constitutional protection. And these procedural issues actually continued even after he was locked up. Under Article 41, citizens have the right to criticize and report state organs. Well, while in prison, Chen wrote what was described as a blood letter trying to formally report judicial corruption in his case. But the prison guards intercepted it and refused to pass it along. Gemini and Grok immediately flagged this. By blocking that letter, the state actively denied his Article 41 supervisory rights, shutting down his legal avenue for complaint entirely. Section 6. AI Constitutional Conclusions. Synthesizing the verdict. When you pull all of this together, the results are remarkably unified. Think about it. These are 6 different models built by different companies with totally different architectures from all over the globe. Yet they all independently arrived at the exact same conclusion. Across the board, from freedom of speech to academic freedom, the models reached a high consensus that the court's conviction deeply conflicted with the foundational text of the Constitution. Out of all the analyses, Quen provided a particularly powerful summary. It stated, "The true provocateur is not the scholar forwarding tweets, but law enforcers trampling the Constitution in the name of criminal law." That completely shifts the lens. It takes the idea of provocation away from the citizen sharing information and places it squarely on the judicial process itself. As artificial intelligence becomes more and more capable of objectively reading our highest laws, it's starting to hold up a digital mirror to human systems. It forces us to ask, how will societies reconcile the gap between the beautiful rights written on paper and the harsh realities enforced in the courtroom? It is a huge question that goes way beyond Dr. Chen's case, and it's one we are all going to have to answer eventually. Thanks so much for exploring this with us today, and keep questioning the world around you.